I'm Derek Little, and in this session, I'm looking at how cybersecurity decisions actually get made, where they break, even when the risk is clear, and what makes them defensible. Today, I'm speaking with Krishan Thakker, an expert on legal defensibility. Welcome, Krish.
Thank you very much for having me on, Derek.
Okay, before we get into this, can you briefly introduce yourself and your background?
Absolutely. So I'm an attorney practicing for over 16 years, admitted in New York, DC, and Pennsylvania. And I have legal education in both the United States as well as in Europe and the UK. And my practice has spanned multiple continents, predominantly US, Canada, Europe, UK, and most recently LATAM, particularly given my presence in South Florida, where I reside with my family currently. My career sits at the intersection of legal liability, compliance, regulatory, and corporate compliance, as well as aspects of technology such as data privacy and, most importantly, cybersecurity. I spend most of my time advising boards, C-suite executives, vice presidents, and middle-level management, as well as technology companies' product management on things like AI governance, ethics and integrity, and cyber risk. My primary focus, and interest recently with cyber risk governance topics has been what I have called with some colleagues of mine the left of boom, defensibility, which is architecting the legal and strategic frameworks that a public or a private company needs before a catastrophic breach occurs or a government regulatory inquiry ever happens.
Okay, why don't we start with a scenario? Can you walk me through a worst case situation where legal should have been involved early but wasn't, without referencing any of your clients or employers?
Great question, and thank you for diving right in. Yes, I will just want to caveat as well that, even though I'm here in a legal professional capacity, these opinions are of myself and none of my clients, and any kind of opinions and perspectives I provide on this call are not to be construed as legal advice, but more practical, informational advice. But Derek, this happens all the time. And today's Friday, and hoping it doesn't happen, but it could. Ironically, I call it the Friday afternoon trap. At 4:55 p.m. on a Friday afternoon, you get a system administrator that notices an anomalous lateral movement on the computer network of the company, or they get a ransomware ping. IT department's instinct is totally operational. Let's go fix it. So the CISO and the server room team, they spend the remaining of the Friday afternoon, night, unfortunately, most of Saturday and most of Sunday in a frantic G-chat or Slack channel dialogue or a Zoom room, just trying to isolate all their servers, rebooting their systems, and trying to patch the vulnerability. They bring in third-party IT vendors as well that obviously cost them an arm and a leg. And by Monday morning, they still realize they can't contain it. They give a call to the CEO. And by Tuesday afternoon, someone says, hey, we better call the general counsel or legal or someone like Krish. At that point, we have a almost 72-hour exposure gap, because in that window, IT and third-party vendors have created hundreds and hundreds of discoverable pages of written chat logs, vendor tickets, emails, panicking, dialogue saying things like, I told you that we should have patched this up last month, or, we left that bucket open. None of that involved or was directed by or was authored by legal counsel. Therefore, none of it is going to be protected by, what we call attorney-client privilege or the attorney work product doctrine. In this situation, whether it's the government or a ambitious ambulance-chasing plaintiff attorney, the opposing lawyers, they're going to try and subpoena all of it, and it'll become most likely an exhibit in a class action lawsuit or an SEC inquiry, as worst case scenario in that situation. That's kind of a textbook example of what lawyers in my seat have certainly been through. And that, I think, is definitely a worst case situation where legal should have been involved early on.
So what would have changed if legal was involved earlier?
So attorney-client privilege and attorney work product would have been triggered. The privilege, however, doesn't just magically apply because you CC a lawyer on an email chain. To be privileged, the investigation and the communications must be conducted in the direction of an attorney in anticipation of litigation. If IT is just troubleshooting an outage, that's standard business operations as usual. It's going to be discoverable. But what should have happened is the general counsel should have received a call on the same Friday. The general counsel would have typically, assuming the right internal policies, practices, and procedures are in place, had an escalation pathway where they hire a forensic firm very quickly to determine the liability and the extent of liability. And that in and of itself, the communications, the work product, would be legally protected from discovery, so as to minimize outward exposure.
So from that scenario, what would determine whether something is actually protected under privilege? I don't know whether you answered that already.
Yeah, so that, the biggest exposure point is obviously the communication channel during the crisis, and that's what we're trying to protect under privilege and work product. So it's the communications between IT and legal seeking legal advice. It's not every communication, like I said, that is legally privileged if you just copy a lawyer or you have a lawyer passively listening into a phone call. It's when a client, which owns the privilege, by the way, is speaking to a lawyer, soliciting and requesting legal advice, and the attorney in response is providing that response, which is legal in nature. And those communication channels between the GC and the IT department, as well as the GC and the forensic firm, are legally protected. So, as I was saying, it's the communication channels. Even third-party communications between the general counsel and the vendor arguably could be protected by privilege if there's an agreement in place extending that privilege with a third party, as long as it's contained. The agreement is drafted narrowly, the scope of work is vetted carefully, and the vendor obviously signs and consents that they are acting under this company's privilege, being instructed by the general counsel. It's privilege, as I mentioned, belongs to the client. It's usually the client that can waive it, not the attorneys, which is an important caveat, which we can get into a bit later on. All the messages in this situation, the texts, the Teams dialogue, the emails, all of that would be subject to these rules. And from my experience, IT professionals are very honest problem solvers for the most part. They diagnose the company's negligence in real time in a chat channel. But if the office of the general counsel's folks aren't in the room within that, say, first hour to establish that privileged communications protocol, the company, unfortunately, is pretty much just writing the plaintiff's lawsuit for them.
Really? So the legal consequences could be maximum, what do you call it, maximum probable loss just with one sentence or something?
Catastrophic, indeed. Consequences are existential. Today we're seeing courts and regulators like the SEC and the FTC treat this kind of delayed reporting and poorly managed internally incident almost as negligence. It leads to also breaches of contract with your vendors and your customers and your sometimes suppliers, massive regulatory fines, and potentially even personal liability for some of the executives if the board feels that they hit the ball.
Okay, well, if that gap gets reviewed earlier, what could be the consequences? I'm not sure if you already answered that one
Yeah,
too.
no, I think the question you're asking is like if this was mitigated before and the company did the right things.
Yeah, what's the difference between what felt right and what actually holds up?
So a decision that feels right to say a CISO in a company is shutting down the affected server, wiping out the malware, and restoring things from a backup as fast as possible to get the business back online. A decision that holds up is doing that, but it doesn't do that until and only after preserving the forensic image of the server. Um, Documenting the chain of custody, building a documented audit trail, having the right pathways and departments escalated to, and isolating the logs so that the general counsel or the folks in the legal team can prove to the regulators exactly what data was exfiltrated and exactly what wasn't. It's the defensibility in this situation is about preserving the evidence of your innocence. It's not what is the truth, it's what you can prove, as the axiom goes. A defensible decision, and this is what we got into in the last webinar with my colleagues Stanley, Sean, and Donald. A defensible decision here requires that triad. It's the CISO, the CFO, and the legal team. Looking at that same data from a different lens, but at the same time, balancing the operational need and the balancing that financial, as you said, the maximum probable loss, the MPL, and the legal liability.
So, continuing with what you said about how legal, IT, and leadership will see this differently, where does that misalignment create risk? Like, where is it a breakdown in communication, or just that's not my job?
Well, yeah, Derek. These folks are speaking three almost entirely different corporate languages. IT, CISO, is looking at the network architecture and thinking, how do I stop the bleeding? How do I restore the data? The leadership or the finance department, they're looking at the profit and loss and thinking, what's the maximum probable loss right now, right here? And do we just pay the ransom and be done with it, or do we eat the downtime? And legal, they're looking at damages, they're looking at liability, and they're looking at the contracts, thinking, do we also have a 72-hour mandatory notification for breaches under the GDPR or other applicable cybersecurity privacy laws or under SEC rules? And who are we legally required to tell? And what do we need to tell? And when? And what do we log as privileged and what don't we? That's kind of those types of conversations that have happened and continue to happen, and how those three departments see things differently.
So, what's standing in the way of them getting along and having a common understanding? Is there like a new job role needed on the board, or a new board member who oversees all of this, or?
Good question. It's a complex one. There's different facets to your question. Probably can break it down into two or three parts. So I'd say number one, it's the fragmented data. The CFO is running a risk model, say, just once a year. Also, the GC, they have vendor contracts, but they're unfortunately secure and locked in a PDF drawer. And the CISO, thirdly, they're looking at a live dashboard of network threats. All the data is living in different places. So when the breach actually happens, they're not looking at the same reality. So that's where alignment fails, because there's no real continuous, real-time, ongoing 24/7, 365 days a year unified governance architecture that bridges the server room and the boardroom. And I think that's where cross-functional alignment fails.
Okay. So, from a legal standpoint, now talking about vendors, in that situation, the scenario that we've been discussing, what would make a vendor or a platform defensible when that decision is reviewed later, if anything?
So a defensible platform, to me, again, and reasonable minds may differ, is one that is giving that continuous, auditable proof of compliance. It's not just a mere snapshot. It's a movie, a motion picture. If I'm defending a board, I need a platform that proves we are monitoring access controls, running material change risk assessments, or MCRAs for short, which is also a regulatory term of art, and adhering to frameworks like the NIST Artificial Intelligence Risk Management Framework before the breach happened. Unfortunately, willful blindness to the obvious is no longer a defense. We didn't know is no longer a defense. It's recklessness, if that's going to be your defense, and regulators will bark at it.
So do you think there's what would make choosing a vendor or a platform easier to defend? Is there anything they can do, or is it just really all on the company to get their act together and choose a vendor?
Well, Derek, I think it's a whole segment into a totally different topic, which we could spend hours and hours talking about. But in sum, I think that the biggest unmanaged risk right now is this shadow AI. It's like it's enterprises and well-meaning, honest operational teams that introduce these cool new third-party Gen AI tools into the enterprise. Achieving great ROI, great metrics, great if it's a platform GMV, and then having an AI note taker on a Zoom call, kind of put client data into a public LLM for training purposes without realizing that ultimately they're violating data sovereignty laws. They are bypassing the internal perimeter, and they are potentially waiving, confidentiality. That's kind of, your vendors are your perimeter now. And that's kind of how I look at it.
I see. Okay, I think we've generated some pretty good insights. Is there anything else I should have asked but didn't that you wanted to cover?
Derek, I think you've asked great questions. I think we've nailed the core essence of it all. The only thing I think I could add is that the timeline is compressing. The window to get this right, back then it used to be months. Now, under the new regulatory frameworks, and it's not just GDPR, it's a myriad of different standards and different international laws, cybersecurity laws, and obviously foreign privacy laws and consumer protection laws and AI laws. It's now becoming days or even hours, if not minutes. The time to build your defense today is the left of boom. That's kind of where I think, companies can spend a lot of time doing more investment in and digging and getting training on and getting proactive and building out their, compliance programs and protocols and having the right infrastructure so that when, push comes to shove and things happen on that Friday afternoon, the company is ready to go, and has audited it, has the right people to respond and react so that, time isn't lost, because time is of the essence in these situations. My takeaway at the end of this is that if you want pure financial evaluation perspective on your cyber risk, you should really be speaking with a strategic CFO that really understands maximum probable loss and also the value of institutional capital. The folks that actually have to price this risk for the insurance and the VC markets, they often have a fantastic, but at the same time, terrifying view of the landscape.
Okay, I appreciate you taking the time, Krish.
Thank you very much for having me again, Derek. It's been a pleasure.